Okay, let me ask you something. Imagine you ask a friend to run out and grab you a coffee. Simple enough, right? But what if they come back with a brand new, top-of-the-line, $1,000 espresso machine and they put it on your tab? Are you on the hook for that? Well, that's pretty much the exact problem we're digging into today, but on a much, much bigger scale.
And at the very heart of this story is this number, $350,000. Wow, that's not just some random figure. It's the potential price tag of one single, disputed signature on a piece of paper.
And whose signature was it? Not the CEO, not the CFO. It was a 24-year-old events manager who had only recently been hired. She signed a deal that committed her company to this massive expense.
And that brings us to the big, multi-$100,000 question. Is the company actually legally responsible for a contract that it claims it never, ever approved? Okay, let's get into it.
All right, so first, let's meet the players in this high-stakes drama. On one side, you've got the Stein Eriksen Lodge, a really fancy hotel in Utah. On the other side is MX Technologies, a tech company that was planning a big conference. And right in the middle of it all, MX's events manager, the one who signed the deal.
So to figure out if MX has to pay up, the law looks at this from a couple of different angles. First up, let's step inside the company itself and ask, did this employee have what's legally known as actual authority?
Now, actual authority might sound like some complicated legal jargon, but it's really all about the employee's perspective. The court asks two simple things. One, did she honestly, genuinely believe she had the green light to sign? And two, was that belief reasonable, based on what her company had said or done?
And, yep, right off the bat, we've got a huge problem. MX had a crystal clear policy. Anything over 20 grand needed the chief financial officer's signature. This contract was for more than 17 times that limit, and she never, ever got that CFO approval. That alone makes her belief look, well, not so reasonable.
But hold on, this is where it gets messy. When she was questioned under oath, the events manager said, "Look, I know I didn't talk to the CFO, but I did get approval from my direct boss, the marketing director."
But when the marketing director was asked about it, she told a completely different story. She testified that she absolutely did not give approval, and in fact, she didn't even know the contracts had been signed until months down the road. So now you've got this classic he said, she said, or in this case, she said situation.
So, what's the verdict on actual authority? Well, it's a total stalemate. You've got two key people, both under oath, saying the complete opposite. A judge can't just pick a side. That's a job for a jury, which means this has to go to trial.
But wait, the story's not over. The hotel has another card to play. So now we have to shift our perspective. Let's step outside the company and look at this from the hotel's point of view. This brings us to a new concept, apparent authority. Apparent authority has nothing to do with what the employee was thinking. It's all about what the other party, the hotel in this case, could have reasonably believed. The question is, did MX do something that sent a message to the outside world that this employee had the power to sign a $350,000 deal? And what was the hotel's big piece of evidence for this? It's actually super simple. Her job title. MX called her the events manager. The hotel argued, hey, by giving her that title, MX was basically advertising to everyone that she was the person in charge of managing events, and that includes signing contracts for them.
So let's just pause for a second to make sure this is totally clear, because it's really the heart of the case. Actual authority is about the internal conversation between the company and the employee. Apparent authority is all about the external message the company is sending out to the world. They're two completely different tests.
So what about apparent authority? Did she have it? Well, once again, the court basically said, maybe. A jury might look at her title and say, yeah, events manager, sounds official enough. But it's not a slam dunk, so a judge couldn't decide this one on their own either.
This brings us to the hotel's third and final argument. It's kind of like a legal Hail Mary. The idea is, even if she had zero authority when she first signed the contract, did MX approve the deal after the fact through its actions? This is called ratification.
Ratification is basically the legal version of giving a retroactive thumbs up. If a company finds out about an unauthorized deal, but then starts acting like the deal is real, enjoying the benefits of it, the law says they've ratified it. And if they ratify it, they're stuck with it.
And the hotel came with a list. They pointed to a whole bunch of things MX did that sure looked like they were moving forward.
MX people visited the hotel to check it out, they hired a big-name speaker for the event, they put the conference info up on their website, and they even asked the hotel for video footage to use for marketing. The hotel's argument was, come on, these aren't the actions of a company that thinks the deal is fake.
But MX fired back with a really important question here. They basically said, hold on, all that stuff just proves we were planning for an event that might happen. It doesn't prove that the top bosses knew about and approved the specific expensive terms of this particular $350,000 contract.
So we've got all these conflicting stories, these different legal arguments, a real mess. What did the court finally decide to do about all this?
Well, the big reveal is there's no winner, at least not yet. The appeals court basically hit the big pause button. They overturned an earlier ruling and said on every single one of these issues, there are major questions of fact that are in dispute. And when the facts are this messy, a judge can't decide alone. So the case was sent back down for a full-blown trial, where a jury will have to listen to everyone and decide who they believe.
So after all that legal back and forth, what are the real-world lessons here? Well, it's pretty straightforward. For companies, have clear rules about who can spend money and make sure everybody knows them. For employees, a verbal go-ahead on a huge deal isn't enough. Get it in writing. It could save your job. And for anyone doing business, if a deal feels way too big for the person you're talking to, just make a quick call to their boss to double-check. It can save you a world of hurt.
And that's what I want to leave you with. Take a second and think about your own job, your own company. Is it crystal clear who has the authority to sign on the dotted line? Or is it kind of fuzzy, dangerously ambiguous, just waiting for its own $350,000 mistake to happen?